Welcome to class, students! Pay close attention today because this explainer is your absolute blueprint for the Indian Contract Act 1872. We are structuring this session exactly like a 16-mark model answer script for your KSLU examination. If you followed this exact framework, you'll present a flawless, high-scoring paper. All right, let's get straight into it. Here is our roadmap for the perfect answer. We'll start with the definition and parties, move to the nature of the contract, and then examine the scope and liability. After that, we'll break down the landmark Bank of Bihar case law, compare indemnity versus guarantee, and wrap up with a solid conclusion for your exam. Memorize this synopsis and write it on the very first page of your answer booklet. It instantly commands the evaluator's attention. So, Section 1, Definition and Parties. Focusing specifically on Section 126 of the Indian Contract Act 1872. You must never start an answer vaguely. Always anchor it to the specific section of the bare act. According to Section 126, a contract of guarantee is a contract to perform the promise or discharge the liability of a third person in case of his default. Now listen to me carefully. You absolutely must underline the phrases perform the promise and discharge the liability in your exam script. The KSLU examiner is actively scanning your paper for these exact statutory terms. Under that same heading, you need to clearly delineate the three parties involved. First, we have the surety, the person who actually gives the guarantee. Second is the principal debtor, the person whose default is being guaranteed. And third is the creditor, the person to whom the guarantee is given. Use a clear bulleted list in your paper just like this. It's a tripartite relationship, and showing this structure proves you grasp the core machinery of the contract. Moving on to Section 2, the nature of the contract and the essential elements of a valid guarantee. To score maximum marks here, you need to break the nature of the contract down into 5 distinct, numbered headings. Number 1, it's a tripartite agreement between the surety, principal debtor, and creditor. Number 2, secondary liability. This is crucial. It arises only when the principal debtor defaults. Number 3, existence of primary liability. There must be a valid existing debt. Number 4, consideration. The consideration received by the principal debtor is completely sufficient for the surety. And number 5, it can be express or implied, meaning written, oral, or inferred from conduct. Now, in your exam, I want you to elaborate heavily on point number 2. Make it explicitly clear that the surety's liability is strictly secondary. They step into the arena only after the principal debtor fails. It's a backup mechanism, not the frontline obligation. Next is Section 3, Scope and Liability, which covers the extent of the surety's obligation under Section 128. Let's analyze the absolute extent of this liability. First, it acts as a security for debt, giving that extra layer of comfort to the creditor. Second, and mark this well, the extent of liability. The surety's liability is coextensive with that of the principal debtor, governed by Section 128. Third, you briefly mention the rights of the surety against the debtor, creditor, and co-sureties, but the undeniable key for your paper is Section 128. You need to underline the word coextensive multiple times. It means the surety is on the hook for the exact same amount and scope as the primary debtor. No more, no less. Also under scope, you must explain the types of guarantees. Draw a very clear definitional line. A specific guarantee is for a single isolated transaction. A continuing guarantee extends to a series of transactions over time. Show the evaluator you truly understand the temporal scope of the risk. Does the risk extinguish after one loan is repaid, or does it run continuously over a series of dealings? Be precise. That brings us to Section 4, the Bank of Bihar case law, a landmark judgment on coextensive liability. This is the mandatory case law dissection, and frankly, this is exactly what separates a university topper from an average student. Bank of Bihar v. Damodar Prasad. When you write this case name on your exam sheet, put it in a separate, cleanly bordered box. Make it prominent. The evaluator simply shouldn't be able to miss it when scanning your answer. Let's break down the exact judicial ruling. The brief background here is that a creditor sought to recover dues, and the surety tried to act clever. The surety argued that the creditor must first exhaust all possible remedies against the principal debtor before coming after them. Well, the court flatly rejected this. The ratio decidendi here is that the surety's liability is immediate and coextensive. The legal application? The creditor can proceed directly against the surety. And the absolute relevance of this case, why you must write it down, is that there is no need to exhaust remedies against the principal debtor first. It solidifies Section 128 and grants immediate power to the creditor without facing procedural delays. Explain this deliberately in your paper. Section 5. Indemnity versus guarantee. We are going to build a comparative framework. For this section, drawing a strict margin table in your answer script is non-negotiable for securing top marks. Let's compare them directly. By definition, indemnity is a promise to save from loss, whereas a guarantee is a promise to discharge the liability of a third person. Indemnity has only two parties. A guarantee has three. Liability in indemnity is primary, but in a guarantee, as we've discussed, it's strictly secondary. Indemnity is an independent contract, while a guarantee is a collateral contract. For indemnity to trigger, actual loss must occur. For a guarantee, default by the debtor triggers it. Think of insurance as your classic indemnity and a loan guarantee for, well, a guarantee. This visual table gives the examiner a comprehensive summary of your legal knowledge in one quick glance. Gajanan Moreshwars versus Moreshwar Madan. Immediately following your comparison table, I want you to box the second landmark case. Again, high contrast, prominent placement. This proves your deep jurisprudential understanding of the distinction between these concepts. Here is your exact breakdown for this case. The facts? The plaintiff transferred a plot of land to the defendant, and the defendant promised to indemnify him against any claims from a material supplier. When sued, the court ruled that the plaintiff didn't have to wait to suffer actual out-of-pocket loss to trigger the indemnity. The judicial focus here explained the true nature of indemnity versus guarantee. It highlighted the strict differences in liability. It is incredibly relevant because the court historically separated an independent contract of indemnity, where liability can be absolute upon the threat of loss, from the collateral nature of a guarantee, where the surety only triggers upon the primary debtor's default. Showing this historical application proves you really know your stuff. Finally, Section 6, Conclusion for Exam. This is our final assessment of these commercial tools. Never ever leave a 16-mark answer hanging. You must provide a definitive, forceful conclusion. Summarize it like this. A guarantee is an essential commercial tool facilitating credit and trust in transactions. While indemnity protects strictly against loss, a guarantee provides strict security against default. Understanding this distinction is absolutely crucial for proper application in both legal and business contexts. Frame your concluding paragraph exactly like this to tie your entire legal argument together beautifully. It shows tremendous maturity. As we wrap up this explainer, I want to leave you with a provocative thought for your advanced studies. If a surety's liability is purely secondary, meaning it depends entirely on the existence of a valid primary debt, what happens to the commercial trust if that primary debt is discovered to be void from the very beginning? Ponder the deeper layers of primary liability existence as you prepare. Master this blueprint, follow this structure rigidly, and those 16 marks are yours. Best of luck with your studies.